my original request discussing critical mention. You said you did not produce this document, correct?
For those who are behind or not familiar with the first video, there's a part 1 to this. So I would encourage you to watch that one first and then probably watch this one, or you can, either way it goes, but part 1 will give you more context to what this one is about. I just forgot to finish up part 2 to this, so I'm going to do it now.
No, I don't believe so.
Did you assist in retrieving these documents?
For these particular documents, no. These documents appear to be responsive to your open records request. It appears to be delivered to you on January 18th, and it appears to be responsive to your request.
You can look at 0055. If you go down a little on this one, see where it's after Melissa Fritz, it says Fonnie Willis critical mention search. It's a different font, and then PR value for the week, and then there's a couple other things. This, and we now know, because we have the actual emails, we now know this is 4 or 5 different emails that were pieced together. Did you participate in the cutting and pasting of these documents?
Objection, Your Honor. Objection, Your Honor. Presumes that he cut and paste documents, and that was never established by his testimony. So we're objecting to that.
Okay, well, for now, I'm going to sustain your objection to the characterization of the cutting and pasting, but you can certainly ask him if he participated in the creation or generation of this document that was produced to you, however it came to exist. So your objection is sustained to that extent, Ms. Monroe.
And Judge, I thought that it was Mr. Bowman's witness. I might be mistaken, but I prefer not to tag team.
I do agree. I apologize. Who is going to be examining this witness?
I will.
Oh, okay. Well, then fair enough.
I didn't know that was a thing.
Well,
I mean,
Mr.
generally-
Bowman had objected, so.
Yeah, generally speaking, whoever's going to be examining the witness is the one who should be controlling the objections. And I think Ms. Merchant's expressed concern was she thought Mr. Bowman was going to question this witness, which would make your objection problematic. But since you're going to be examining the witness, it's fine.
That's fine.
I'll frame for the honor.
Well, usually I just ask that you whisper in your partner's ear so they can then say the thing that you want them to say.
And I showed Mr. Bowman the documents because he had made the first objection, so I just was assuming that was the path, but I will check. Okay, so this document, however it was created, did you assist in the creation of this page?
No, I think you and I agree that the first request was straightforward. I don't think that this was elevated to me. On January 18th, no, it was not elevated to me.
Who compiled the document in the form that we see it in here today?
A member of my staff. That's an assumption. A member of my staff.
Okay, so you're assuming, but you don't know who compiled this?
Specifically,
Yes.
on January 18th, yes, this is a designated employee, yes.
You're positive it's a designated employee?
Well, okay. Yes, I'm positive I know who that is.
Who is it?
Erica Willingham.
Erica Willingham. So Erica Willingham is who we would need to ask, not you as the records custodian, about how this document was created.
I cannot answer that question. Let me explain why, right? Typically, emails are compiled in a certain kind of way, right? And those emails are compiled by IT, by staff. It may be compiled by going to reach out to various different persons. I cannot speak to that.
This is Dexter Bond. He's an assistant district attorney or a deputy district attorney for the Fulton County DA's office that Ashleigh Merchant has put on the stand as a witness in regards to records requests that she asked for regarding one of her clients during the Trump RICO case for the 2020 election in Georgia. Right now, he's on cross-examination, but his testimony is very hostile. He's a very hostile witness. If you notice his demeanor, his body language, his tone of his voice, you'll get a lot of that in part 1, but you're going to get more some of that in this part as well. So I just want to give you guys a synopsis of what's going on.
So I cannot tell you if she personally, if the question was, did she compile? I do not know. I do know that she handled it as a member of my staff. I do know that she responded as a member of my staff. I can tell you that.
So you can't say as the records custodian that this is an accurate copy of an original document. Let's put it that way. You really don't know anything about this document.
Not at all.
I do know something. I know it was responsive to your request. So yes, I know something. I think you and I can agree on that.
Let's take a look at, I'm gonna jump out of order, I apologize. If you,
I also know, if I may, that it was provided to you on January 18th. I also know that you received this particular document on January 18th.
He got very offended when she said he don't really know or don't know any knowledge about this record at all. That's why he's giving all that sass to this testimony.
I also know, as you mentioned, that there was a second critical mention document. In that second critical mention, I know you referenced this before, right? I also know that once you referenced this before, you renewed a second critical mention document saying, hey, you gave me this on January 18th, I'm looking for A,
yes,
right?
and we're in
And
there.
that's why you and I on the same page, didn't want it to be global. So I do know information as it relates to this particular request.
And we can actually go there right now. So I filed a second request because my initial request was closed when you all provided this 44-page document, right?
Yes, on January 18th, it was close.
And so on January 18th, I refiled my request and I specifically referenced the original one and said, why are you closing this? You didn't give me everything. Did you?
If I can,
Yes,
I like the fact that you presented the first one and allowed me to read it. Can I read the second
of
one?
course it is. Let's see. I don't have the number off. The second one is. Merchant 0011. Here, take a minute. Oh, doesn't take a minute. There we go. So this one, I said in regards to my prior request, and I referenced that number we just talked about, and I said I requested the critical mention documents, and I say the number. I said I got a set of emails, but I asked for the analytics and the documents that are clearly referenced and attached to those emails. I said reports with analytics were provided to the DA's office monthly. It appears from the emails that Jeff DeSantis, Fonnie Willis, Jeremy Murray, Pallavi Perkasa, Robin Bryant, and Rita Kepler may all have access to these reports on a regular basis. They're public media, paid for by public funds and subject to open records.
Yes, I did receive that. This was elevated to me, and I did respond to you.
Okay, so this one was elevated to you, and you definitely did respond. Before we get there, let's talk about what we were just talking about a minute ago about I don't want to use the word cut and paste, the
Let's go.
document, and I'm going to call it Merchant 55, that appears to have a compilation of several other emails contained within it. Okay, that document we were looking at a minute before, and you said you don't know who prepared that document, right?
I do not know who compiled that. I know who handled the file. I know who sent you the responsive document.
And you don't know where that person got the responsive documents. But you assume it was Jeff DeSantis, is what you said earlier.
I did not say that, ma'am.
You said you would reach out to Jeff DeSantis in Fulton County IT.
But he certainly wouldn't compile any documents for me.
Oh, okay.
Okay?
So who would compile them? Who would, and let's just look then. So you've seen, and can you show him again, Merchant 0055, just take a look at this document, so I'm gonna ask you to compare it to a different one.
Okay.
So just to make sure I'm clear, I thought that Mr. Bond said that he believed that Erica Willingham was the person who compiled the response at Merchant 0055.
I thought he said that she did, but that she would reach out to Jeff DeSantis and the county. First, he said he didn't know who provided it. He said that they would reach out to Jeff DeSantis and Fulton County IT.
Well,
And then
that's
later-
actually why I'm asking for clarification, to make sure we're all having the same conversation, because I understood you to be asking him about who compiled the document that was provided to you, not who obtained the information that was then determined to be responsive and compiled into a document that was provided to you. What I understood Mr. Bond to be saying was, this type of request, I would have reached out to DeSantis and maybe County IT,
Yeah.
and then it was compiled by this particular employee and provided to you.
And I'm not sure. That's the ultimate question. So let me try and be a little more clear then. This document, number 55, okay? It looks as though it's a compilation of other emails, okay? If you look after Melissa Frick's name, it says Fonnie Willis critical mention search, and then PR value for last week, and then there's that middle section that we're talking about, middle section right here. there's no header to from or dates here, there's no header to from dates here, there's no header to from dates there. That, they all look like different emails, right?
I would agree with you.
Okay, so not using the word cut and paste, someone took these parts and put them all in one.
Objection, Your Honor. Is that a question, is a statement? I mean, if it's a question to
Well,
the,
he's an adverse witness, so she can cross-examine if she wants to, number one. Number two,
Judges,
the reason I said we were not gonna call it cut and paste is that assumes facts that are not yet evidence. Now, you can ask questions about assumptions that you're drawing from the appearance of the document, but that's why I've said we're not gonna call it cut and paste. Now, I think the witnesses called it a compilation, so why don't we call it that for a while until we decide that it's something else?
So this appears to be a compilation of several different emails into one.
I agree, compilation, yes.
Okay.
And if, go ahead.
No, that's okay, we're here to learn from you, tell us, what were you saying?
No, I'm agreeing with you. That does appear to be a compilation of emails.
Okay, and can you pull up merchant 0167? So there's a redacted section here, and then you can see under that, I sent a story via critical mention a few minutes ago, direct link below. Okay, so this, and this were removed from that email. It just starts with I sent a story via critical mention. All of that is not in that compilation document, right?
As it relates to the headers.
As it relates to the sorry?
This,
Yes,
it does not appear to be so.
so this was all removed. And the document just starts right there.
I cannot tell you if it was removed. I think my testimony, Your Honor, is that this particular request came in January 8th, right? We responded on January 9th. On January 18th, we responded to the documents, right? Once we responded to the documents, you accepted it. What I need you to hear is we closed that particular file. It was not elevated to me. Your second one was elevated to me. Let's call that critical mention 2, if I may. That critical mention 2 referenced the first critical mention, right? In that critical mention 2 that you just displayed to me, it had only one specific item. I am looking for analytical graphs. I responded to that request. So as it relates to anything that from the first time I gave it to you, it was responsive because this is me as the business record custodian. Once I received the second critical mention reference that referred to the first, you and I can agree that the first had, let's just say 5 things. You only made mention of one thing in the second one. I assumed 1, 2, 3, 4 was resolved, that is closed. And I responded on January 26th to the remaining issue. So as it relates to compilation, I want to be very clear. It was sent to you. It was responsive to your request. I moved on. You referenced it. Once you referenced it, it was elevated to me. The elevation was one specific item. So I assumed that the first matter was resolved and the only outstanding issue related was
I think that's where he messed up at, is he assumed that he didn't fact check. That's what she's trying to get at. I'll continue to though. But you want to check your, verify everything, not just to take an assumption, because you know what they say. When you make an assumption, you make an ass out of yourself.
analytical drafts embedded into something, which I responded to you on January 26th. Is that clear?
No,
Okay.
and so let me break it up because it was a lot, so I tried to take notes.
He's getting hostile, like, is that clear? And she said, no, it's not.
First, you said I accepted it. So on January, whatever the date was, 18th, I accepted it. When you said I accepted it, you sent me a document and I accessed it and it was immediately closed. So you're saying that's an acceptance of the open records response?
I am saying that we sent you the open records response that's responsive to your request.
Yes.
All right. I am also saying that you opened up another open records request. In your second open records request, that's why it's very important we do not refer to this as globally. You make reference to the first.
Yes.
You said here in court that the first one was very detailed, in which I agree. Okay? I let you know that I did not have anything to do with that. You gave responsive records. Once you respond to me in reference to the first one, and there's one thing outside, I am a reasonable person, that's the word that you use, will assume that the first is over. It's done. It's complete. So I am assuming, reasonable or not, that you accepted the open records request because you said, here's the second one. I did this. I'm referencing that, and here's a small section.
So you assumed I accepted it and.
It was
Hold on,
delivered.
hold on.
Does that matter?
Delivered.
It was sent to you on January 18th.
Yes.
No, there is no reason to argue about semantics of what we're talking about. It is not a dispute that on the whatever day it is that the Open Records Act portal sent you a batch of documents. And then I don't think it's in dispute that that request was closed and then you followed up on it, which the county or the Fulton County, whatever we're gonna call it, treated as a new request that referenced a prior request. We don't have to argue about whether it was accepted or received or acknowledged or whatever. The facts are what happened. Let's move on.
So you said that it was, that was responsive to my request, but it didn't completely respond. It only partially responded to my request, the first one. The 44 pages weren't all that you had.
Objection, Your Honor, is that a question or a statement?
It's a question. The 44
Okay,
pages.
hang on. When there's an objection, let me deal with it. We're just gonna put a question mark on the end of Ms. Merchant's statements because technically that's what they are, but they are allowable cross-examination questions, so.
Right, but I want to put the witness in the best position to answer the question, so if it's not posed in the form of a question, I think that's, the onus is on her to pose it in the form of a question as opposed to a statement.
I think that right now I'm gonna, unless I believe that it's being deliberately confusing, which so far it is not, I'm going to allow Ms. Merchant to question the witness. And I'm gonna overrule your objection for now. Go ahead.
Thank you.
You have to repeat your question, I'm sorry.
The 44 pages that you sent me on January 18th, you said that they were responsive to my request, but they were not complete. There were additional documents. Now we have 197 pages. So the 44 were only partially responsive. Is that correct?
Okay. I have an issue with your question, so let me break that down, okay? As it relates to you, I have testified that on January 18th, a member of my staff responded to you and provided you responsive documents, okay? So you as in Dexter Bond did not give you anything, okay, on January 18th. The responsive request for your records that sought 5 things were given to you on January 18th. The answer is yes. On the next day, as you just testified, a new open request was opened. You made reference to the first request, right? Of that, again, the first request was 5 things. You only asked about one thing. The first one was never elevated to me, okay? The second one I responded to on January 26th.
So my question, to answer my question, the 44 pages that you provided, your office provided on January 18th, that is not all the documents that were responsive to the original request. It was only partially what was responsive. Correct?
At the time on January 19th, I couldn't answer that question. I don't know. I don't know.
So you gave me documents, or your office gave me documents, and then you have now certified 10 days ago that 197 pages are the actual.
2 different things.
Yes.
So I'm glad that we was
So,
able
and
to
hold
talk.
on. So now we've got 197 documents.
Okay.
Back then we had 44.
Let me,
Okay, hold on. Those 197 page documents, those existed in January when I made my request, correct?
I cannot say that.
You don't know if they existed?
May I respond?
If you answer my question first, I'm happy to allow you however much time you want to respond.
Okay.
Did those documents exist in January? The 197 pages? Your business record certificate?
I cannot answer that question. May I?
I'm not sure why he took his glasses off, trying to get all technical with her, because she's really just throwing him on the stand as a witness. Ashleigh Merchant is a good lawyer in the South, one of the best in Georgia. very good at her cross-examination skills. She also represented Young Thug's attorney, Brian Steele, when he got into that debacle with Judge Glanville during the YSL RICO case. So yeah, she's doing a great job at cross-examining him. He doesn't have the answers, or even if he does, he doesn't seem to know much, or he lacks the knowledge of certain things, and certain things he's aware of pretty much.
Explain.
Why you can't answer it?
No, let me explain why I cannot answer it. That's correct. Let me explain. Your open records request that you presented asks for certain things, right? I'm assuming that you are talking about the production of documents that you gave on August 30th, right?
Yes.
All right. In that production of document, I'm assuming you're saying that was 197. What I am saying that I cannot correspond, because it's my assertion that the open records request that you received on January 18th is different in scope from the subpoena you requested. And because there is a difference in scope, because your subpoena was more specific, I cannot tell you if the two are correlated. So I cannot answer your question.
So you can't tell me if the 197 pages that you provided on August 30th, that those existed in January?
Yes, they would have existed. The 197 pages should have existed. However, I cannot tell you, let me be very clear, that the 197 pages that you received on August 30th as a response to your subpoena was responsive and should have been included in the 44. I'm afraid that you are looking at an open records request that you received on January 18th, accepted with no reservation. You're convoluting a subpoena. There's two different scopes. There's two different, your search terms were different. So yes, the 197 did exist in January 18 because the scope in which you asked for was from January 2021 to the present, whenever the subpoena came in, right? We did that through IT. Those documents you could certify. I cannot tell you if those 197 were responsive to the 44 because your open records request and your subpoena are different. Your subpoena is more specific.
Okay, so my open records, my first one said that I was seeking a copy of any and all correspondence to or from critical mention, copies of contracts, payments, analytics, and reports, okay? So correspondence, that's emails.
More.
Correspondence is emails.
And I gave you emails.
The 44 pages versus the 197 pages. Would you agree with me that there are a lot of emails in the 197 pages that were not contained in the 44 pages? A lot of emails. We can go through them page by page if you'd like.
If that's what you prefer.
It is not. It's
Okay.
definitely not.
What I am telling you, and I need to be very clear, that your subpoena that produced 197 pages, right? It required, look at this particular email to and from, right? As it relates to these particular search terms. So your subpoena was filled out and given to the Fulton County IT department, and those 197 pages were given, researched, and provided. Let's look back at your open records request. There were no search terms. If I am not mistaken, and you may have to bring it up to reflect my memory, you just wanted something about to and from the vendor or something like that. They are two different things, two different scope. So if you're making an inference of 44 versus 197, I cannot buy into that inference because I see logically why 197 and 44 could be different.
And I'm trying to break it down simply so that we can just get through one item at a time. My original open records request, we're only talking about correspondence. You and I agree correspondence includes emails, correct?
I agree.
And would you agree that the 44 pages did not contain a lot of emails that the 197 contained?
I can concede that.
Okay. The next classification is contracts. Okay, so I asked for contracts between the DA and critical mention. Okay, would you concede that the contracts I got in the 44 pages with my open records request did not contain all of the contracts I got in the 197 pages? Would you concede that?
No, I cannot concede that. You have to show me that.
Okay, that's not a problem.
You
Which
have to
one?
show me that.
So we'll break it down even further. In the 44 pages, the original request, you only gave me a contract for the first year of critical metric, correct?
Show me.
Okay, let's see. Okay, the 44 pages start at, just so everyone knows, they start at merchant 0027. And that one may take a few more minutes to get up because we didn't have that one queued. Oh yeah, 0027. And if you want a hard copy of the documents, I can give you that as well. Okay, in response to that, if you go through the next couple of pages, is it easy to pull up the next couple of pages? Yeah, let me give you the exact page. It's actually the next page, 0028. And I didn't have that one queued up, but we'll have it in a minute, sorry. Or I can just show you.
That's fine.
It's 0028. That's the February 2021 contract for critical mention. Oh, there we go.
I'm glad you said that. I'm glad you showed me this isn't a contract.
No, this is not. This is part of it, and if you go through.
You and I just had a conversation about emails. I conceded. Now you're talking about contracts. I told you to show me. Now you show me an invoice. Which is it? Do you have a contract?
Wow.
I mean, I don't care if you ask me questions, but I don't really think it's appropriate if you ask me questions.
Well, I'm not, you're not obligated to answer the questions he asks you. I would just encourage everybody to try and maintain the, a tone of civility and let's move on.
Yes, sure.
So,
That was very hostile. How he asked, "Do you have a con?" That was very hostile. He was very aggressive with it. I don't really like his testimony at all. And she just really, she's slapping people on the wrist pretty much, but she's not really trying to maintain order in her courtroom. Not to me, at least. She just laid back, look, facial expression.
go back. The 44 pages. I'm going to give you the 44 pages. Okay? So you can just look at that. We don't have to go.
Are you going to point out the contract in the 44?
Give me 1 second.
Oh, okay.
Okay.
I'm sorry.
So my open records request to you asked for contracts. Okay? That was one of the classifications we just talked about, right?
Yes.
Okay. Show me where in there you gave me contracts.
I didn't. I don't believe it's in here. You could not show me. So do you want me to go page by page? Because you said that you was going to show me.
I want
You gave me an invoice, right?
Okay.
And then I said, all right, the 44. So now I can go through here to determine the contract. So you put, I'll do it.
So
But you said that you was going to show me.
I'm going to show you the one you gave me,
Okay, no.
but that's
This is not how you behave as a witness. I'm just showing you as an example. It's improper. It's inappropriate. It's not proper courtroom decorum at all. This is a mockery. But this is Fulton County, so you wouldn't expect nothing less from that county. I'm actually a former resident of Fulton County, so I would know how they operate as far as their system goes. APD is terrible. The courts is terrible. District Attorney's Office is terrible. Sorry, Fonnie Willis. I just got to call it how I see it. Your entire office is terrible. And he's a reflection of that.
the second
You were
request.
talking in the context of these 44 pages. You told this court that I gave you a contract. I said, show me. You approached me with the invoice.
You gave me
I
that
told
invoice.
you-
Okay, stop. Both of you.
Because she has to play referee. It's like two kids arguing back and forth. And it's like, what's going on here? Y'all are all adults.
The question I think is pending that will actually help us move forward is that Ms. Merchant asked if any contracts were produced in the original 44-page production.
Yes.
And while none of us will necessarily enjoy that endeavor, it is perfectly fair for a witness to say, let me review the 44 pages and then I'll answer your question. And so if you would like to do that, you feel free to do that. But the question is, was a contract produced in the initial production of 44 pages? Because I think we had agreed that contracts were requested.
Yes.
Okay, go ahead. Mr. Bond, if you want to go through the documents, or if you want Ms. Merchant to direct your attention to something, we can do that, but the 44 pages is entirely fair for you to say, let me look at these documents before I answer your question.
Yes, I would like for you to direct my attention as you said you could.
I'm asking you to answer the question the judge just asked you that I originally asked you. I asked you if you gave me a contract in January. We agreed that I asked for a contract, okay? So we agreed I asked for a contract. I want you to show me where you gave me a contract. Or if you didn't, tell me you didn't.
Okay, allow me to review.
Right.
This invoice. Based on what you presented to me, assuming that there are 44 pages here, no, a contract is not in this.
In the 197-page document that has your sworn certificate on it, did you provide me with a contract?
May you direct me to that contract?
I give you the 197 pages. It's your sworn business record certificate that you swore to the court was accurate and complete. Give me a moment to reorder that. Let's see. Would you prefer it on the screen or in person?
In person, please.
I'm going to give you one of them as an example. Yeah, first.
Hold on, y'all.
Yes, and you don't have to ask every time.
Thank you. It's called renewal or just happened.
Ms. Merchant, I'm sorry, I can't hear you when you step away from the podium very well.
Sorry, thank you for reminding me of that.
The renewal statement of work, if this is in my file, you are, this is a contract.
It is. Okay, so what I just showed you was the contract, one of the contracts for critical mention, correct?
You showed me a renewal statement of work.
And that was not provided in January of 2024, correct?
It does not appear to be so.
I'm going to show you another, I'm sorry,
And if I can, before, I know you're about to move on,
I'm not.
we agree, right, that there were some emails, right? We also, as it relates to the contract, you said that that there were some documents in that particular file that you have in the 197, okay? You also can agree, I hope, that on the second open records request, you brought forth, that was elevated to me, hey, Dexter Bond, I'm only missing with the analytical. So you and I can agree that any contract or anything was not in your, any open records request. We can agree to that?
No, we cannot. Can you pull up merchant 0055, please?
Like man on the same page as y'all, bro.
Oh, sorry, wrong one. We just had it up, I'm sorry, 0008. I'm seeking a copy of any and all, including copies of all contracts. That is my original request.
Yes, but you and I, you received this on January 18th. On January 19th, you said, you referenced this same open records request, right? And you said, I am only looking for, I received your request, you acknowledge receipt. I am looking for the analytics inside that.
I'm not talking about that yet, and we're gonna be here all day if we go and talk off track. The first open records request, this one, first one, I asked for contracts, okay? I just showed you a contract that you gave me on August 30th. that contract was not provided in response to this open
That kind of
records.
get tired of these folks going around in circles because they're deflecting. Well, he's deflecting, not she. But we're not getting anywhere if we keep going around in circles with the same line of questioning and his same roundabout answers.
Not a follow-up in response to this open records request, correct?
The answer is yes. That contract was not provided in January 18th.
And here's a contract for critical mention for 2021 to 2022. Can you take a look at that?
Yes.
That contract was provided August 30th, but was not provided in response to my open records request, correct?
This statement of work appears to be provided in August 30th.
And you certified the documents that you provided August 30th. Do you have any question about them?
No, I certified the documents on August 30th, but what I need to be clear is once the matter on January 18th was not elevated to me. I think they were clear. When it came to January 26th, you requested 5 things. There was one thing in your second open records request that you brought to my attention. That was elevated to me. I assumed that on
So why you putting emphasis on words like that, sir? This is why we're in this predicament, because you assumed and you didn't fact check. You made an ass out of yourself, sir. That's what they say when you're making an assumption or when you assume. And this is why we are yet here.
the 44 pages, everything else was responsive because you do a good job when you don't get something, bringing it to our attention. We do a good job of responding to you. So yes, you asked for 5 things on January 18th. My staff gave you 44 pages. When you brought forth the second critical mention open records request, of those 5 things, you brought forth 1. That 1 thing was elevated to me. So we make mistakes. If I did not give you a contract on January 18th, I would have loved, as I often hear from you, to get, hey, you're missing this, just like you did on the.
So that slick comment when he said, as I often hear from you, pretty much, actually, Merchant has been requesting records like on a weekly basis, I would say, to get what she wants for her client, which was, it's all public information that you can go on Fulton County's DA's office to request anyway. So it was just something that's open to the general public, not just attorneys. But she's been trying to get information for X, Y, and Z amount of months, and it's been getting delayed. Certain records has been deleted, or to his testimony, they've been wiped away due to the cyber attack that they had a couple years ago, or I believe a year ago or so. So that's why he made that type of reference.
Critical mention analytics scribe, you did not bring that up.
Judge, this is not responsive to my questions. I mean, at all. Not even close to responsive.
I generally try to let the witness answer the way that the witness wants to answer. I will, however, say that I think we are getting bogged down in what previously did or didn't happen based on people's characterizations and understandings rather than, and I think one thing that would help, Ms. Merchant, is if you would ask short, clear, direct, factually based, and not argumentative questions. And then Mr. Bond will do his best to give short, concise, factually based responses that are not argumentative. Because I understand that both of you have a position that you wish to vindicate about what you did or what you think did or did not happen here. But we need to set that aside. Go ahead, Ms. Merchant.
Just asking you about my first request. We're on to the third category, payments. I asked for payments. How critical mention was paid, correct?
You asked for contracts in or payments on January 18th.
In this open records response, did you give me payments for critical mention?
I gave you 44 documents that I believe was completely responsive to your request.
Mr. Bond, you did not give me a copy of the payments for critical mention.
And when I reviewed the 44, I did not see a payment.
And you also did not give me any analytics, correct? In response to this one, just this one.
On January 18th, no, I do not believe. When you say analytics, I don't even know what you're talking about. Are you talking about the graphs that's embedded in the critical mention? I don't know what you mean by analytics. Let me make sure I'm clear.
The critical mention analytics reports.
The same analytics reports that you asked for in the second critical mention request?
Only asking you about the first one.
So no. The
No.
answer is no.
Okay.
Not in
Did you give
January.
me any of the critical mention reports in response to this request?
The answer is no.
So the 5 categories, correspondence, emails, contracts, payments, analytics, and reports, you did not give me any of those 5.
I gave you 44 pages.
So now we'll move to the second request. So when I got those 44 pages and was not happy with the response, I filed a follow-up open records request. Would you agree with that?
Hang on, Ms. Merchant, to my point about argumentative, right? This is further complicated by the fact that you're also your own witness. And so your questions are not only tending to be argumentative, but filled with facts that haven't been established yet. So
Okay, and that was
work on that.
and I was drawing from what he said about me.
Then reference the document. I think that'll be a cleaner way to keep the record clear. That way we know it's a fact that's in the record.
That same day, January 18th, now I'm talking about that second open records request. I followed up and asked for more documents, correct? I'm just asking if I followed up and asked for more documents.
May I answer this question this way? You pointed out the 5 categories. Thank you for doing that, okay? In your second open records request, you asked for not more, the same documents in one. To me, that was interpreted as you have satisfied my open records request, so I cannot say if you was unhappy.
Whenever a witness, especially somebody who practiced law, gives an answer with a backstory to it, with more like backfeed, they don't know the answer or they're lying pretty much. They don't want to get caught up, so they're trying to prevent themselves from perjuring themselves. But you can tell how he's answering. He's trying to be very, very careful by taking deep pauses and breaths before he answers her question.
However, of those 5 things, there is one thing in here that you're missing. Can you respond to that one thing?
So let's talk about that second open records request. So I submitted another open records request and asked for more items, correct?
You asked on that second open records request for the analytics graphs. That was also asked for in the first open records request.
And was not provided in the first open records request.
It was not provided, well, based on my review today, no, it was not provided.
And it was also not provided in response to the second open records request.
So on the second one, a response was provided via the Open Records Act. That response on January 26th, footnote 1 reads, no, on January 26th, I don't know what subsection said, essentially, forgive me legal terms, I don't know what you're talking about. Your response, your ask is not reasonably calculated to put me, the business record custodian, in a position to know what you're talking about. At that time, I did not know what analytics graphs were. I didn't know what you were talking about. So you can reference my letter, which I addressed this second open records request personally because it was elevated to me.
I will in a minute, but let me re-ask my question.
Okay.
Did you provide me any analytics in response to my second open records request?
I provided you a response.
Did you?
In my response,
Hang on.
there was,
Hang on. She's asked you a yes or no question. I think you can
Thank you.
answer and then explain.
yes, ma'am.
Thank you.
No, I did not give you any documents. I did give you a response. That response said, pursuant to OCGA, Open Records Act, that it is not your request, as stated, is not reasonably calculated to put me in a position to know what you are talking about.
On January 24th, I sent your office a letter talking about this open records request again, the critical mention, media monitoring data. And that's at Merchant 0083. If you want to take a look at it, we'll have it up in a minute. Do you recall receiving that letter?
I recall receiving a letter from you, but I do know that that letter was not exclusively for critical mention.
That's correct.
Okay.
That's
Just
not my
making sure.
question. My question is, do you recall receiving that letter?
Yes.
So let's look at what section of it talks about critical mention. I was following up, and this was asking to please not have to go into a lawsuit, right? That's what this letter was.
I don't know what this letter was, but I do recall seeing it. I don't know if it was a please not going into this lawsuit.
So it was entitled Numerous Outstanding Open Records Requests and Notice of Potential Official Complaint and Potential Civil Action. Do you recall that?
I don't recall the title, but I do recall receiving the letter.
Okay. And you recall generally the contents of the letter?
Yes.
And specifically, let's talk about the critical mention. I asked, and this is on merchant 0083, I outlined again what I had been asking for, and provided even more context in regards to these emails, analytics, things like that. Do you remember receiving this?
I do.
Okay. And you responded, and this would be merchant 0087 if you want to pull it up. This is a letter you referenced earlier. So this is the letter you're saying is from you, correct?
Yes.
It's not signed and it doesn't have your name on it, but you're saying that this is your letter.
Yes.
You drafted this letter?
Yes.
And
What was the page number of that? I'm sorry.
sorry, it's merchant 0087
Thank you.
through 88. The only name on this letter is Bonnie Willis, correct?
You have to show me that.
You can scroll. Is the only name on this letter Bonnie Willis?
Are you referring to the letterhead?
I'm referring to who, someone who received this letter, would think it came from.
Okay, well, I'm gonna stop you there because that calls for speculation, but if you could go to the bottom of the document, maybe we could see who signed it. Thank you.
And we just talked about nobody signed it. On the next page, 88, you know that you did not sign it, correct?
I will have to see the second page.
You can pull up the next page, it's 88. Here, I give you.
I believe it was the Open Records Unit or Division. Open Records, sincerely Open Records.
Okay.
So did I sign it? No. But did I draft it? Yes. Is it from my team? Yes.
Looking at this, these two pages, the only name from your office, someone reading this would see is Bonnie Willis, correct?
You would see the only name in her letterhead. Yes. It's any correspondence, I believe, that comes from the portal, any letter is going to have her letterhead on it.
My question is just, that's the only name that's on that document.
I feel like the document is what the document is. Let's move on.
Okay, thank you. This is your response that you were talking about, and just in regards to critical mention, well, actually not just in regards, let me back up for a second. This letter, you said, despite consistent communication, that I was implying that you were still in violation of the open records, and you disagreed with my disingenuous implication.
Because it was. Yes, I made sure that I let you know that you are disingenuous in any implication that I violated the Open Records Act was as such. That was my word choice.
Okay, so the first request, the 5 things I asked for, you didn't give me any of those 5 things, and we've established that.
When you say you,
Your office,
my office gave you responsive documents on January 18th.
right? Some responsive documents, but the 5 categories, and we agreed to that, 5 categories, you said, no, you didn't give me the contracts, no, you didn't give me.
When you say you, my staff gave you responsive documents, okay? We have already said that certain things get elevated to me. You received the records. When you did a second open records request for critical mention of those 5 things, as we have said, you have addressed one. That one thing was brought to my attention, and I handled that one thing. So my assumption, okay, to be clear for the record, was that the first open records request, you received everything. I did not know what was in the 44. You did not, when you brought it up the second time, you did not make mention, right, of anything outside of those 5 things. You only made mention of one. So I dealt with that one thing.
So that was part 2. Part 3 and part 4 will be coming later this week. In addition to that, I'll be doing I'll be finishing up the roommate murder mystery trial. But I just wanted to wrap up that because I did the part 1 about a week ago, or 2 to 3 weeks ago. My thoughts to this is that pretty much he did more assuming than fact checking. He didn't fact check anything. He didn't verify anything. He was not knowledgeable of anything that his office that he works at, what their proper protocol is. I believe his subordinates, his actual team, that's the department he's in charge over, they know more than he does. So I'm not sure why he was even brought as a witness, but more than likely because he was in charge of that department. And that's the thing. You're in that department, but you're not knowledgeable of what the people under you are doing. When you're supposed to be overseeing that department, you would want to be knowing and on top of everything that they're doing that comes through that office, only because, you are an attorney that's working at a district attorney's office. But yeah, it's crazy. Like I said, I'm going to get into part 3 and 4 of this later this week. And then I'm also going to wrap up the roommate murder mystery trial. If you have not watched part 1 to that, or the backstory of the true crime story that I did on Anita Knudsen, please check that out. Like, share, subscribe, and comment. And you guys have a good one.